Hello and welcome to our comprehensive tutorial on indemnity for foreign law and usages as well as force majeure in the context of guarantee. In this video, we will explore key provisions under URDG 758, UCP 600, ISP98 and ISDGP, ensuring you gain a thorough understanding of how these legal frameworks operate in international guarantee and counter guarantee. Indemnity for foreign law and usages. One of the key risks in international guarantees is the possibility that a foreign court or arbitration tribunal may issue an unexpected decision due to unfamiliar foreign law and usages. To mitigate this risk, URDG 758 Article 31 provides an indemnity mechanism. This article states that the instructing party, or in the case of counter guarantee, the counter guarantor, must indemnify the guarantor against all obligations and responsibilities imposed by foreign laws and usages, even if these laws override the guarantee's specified terms. It is important to understand that why this indemnity is required. The guarantor is not expected to have knowledge of all foreign laws and practices. However, this indemnity does not extend to the domestic law of the guarantor's own country, as the guarantor is presumed to be familiar with its own legal framework. A notable aspect is that URDG 758 does not define the term usages. Generally, this refers to any relevant practices related to the enforcement and operation of guarantees. For instance, in some jurisdiction, a beneficiary may have the right to present a claim even after the express expiry date, provided they still hold the original guarantee. This would be considered a foreign law or usage. Regardless of whether the structure involves a simple guarantee or a counter guarantee, the instructing party ultimately bears the responsibility of indemnifying the guarantor and counter guarantor. However, a legal argument may arise concerning whether the instructing party is truly bound by this provision. As they are not a direct party to the demand guarantee or counter guarantee, URDG 758 addresses this is in subarticle 1C, which state that if the demand guarantee or counter guarantee is issued at the request or with the agreement of the instructing party is deemed to have accepted the obligations outlined in the rule. Despite this provision, some instructing parties may argue that since they are not signatories to the guarantee, they are not bound by Article 31. To prevent such disputes, it is considered best practice for guarantor bank to include explicit reference to this indemnity in their facility agreement or other agreements or other arrangements signed by the instructing party. For standby letters of credit governed by ISP98, Rule 8 directly imposes an obligation on the applicant to indemnify the issuer. Now, let's discuss force majeure, a legal concept derived from the French Civil Code. Force majeure refers to an event or circumstance beyond a party's control that prevent them fulfilling contractual obligations. However, it is essential to distinguish between force majeure in the underlying agreement and force majeure in the operation of the demand guarantee or standby letter of credit. Since demand guarantees and standby letters of credit are independent from the underlying agreement, force majeure affecting the underlying contract does not necessarily affect the demand guarantee. Different ICC rules handle force majeure differently, and it is crucial to understand these variations. Now let's discuss UCP 600 and force majeure. Under UCP 600 Article 36, banks are not liable for business interruptions caused by force majeure events such as act of God, riot, civil unrest, war, or terrorism. It is not required to honor or negotiate under the credit that expires during the period of interruption. This means that if the beneficiary is unable to present document due to the closure of the bank, no extension is granted. Now, URDG 758 and force majeure. In contrast, URDG 758 Article 26 offers an extension of 30 calendar days for the presentation of the demand if a force majeure event prevents the guarantor's business operation at the time of the guarantee is set to expire. This extension also applies to the counter guarantees under similar conditions. However, Article 26 does not grant an extension if the beneficiary's business is affected by force majeure. In that case, the guarantee expires as scheduled, and the beneficiary loses the right to present the demand. Now, ISP98 and force majeure. ISP98 Rule 3.14 takes a broader approach to force majeure. If a standby letter of credit specifies a place of presentation that is closed on the last business day for presentation, the deadline is automatically extended by 30 calendar days after the location reopens. Additionally, the issuer has the option to designate an alternative place of presentation, which the beneficiary must use if notified within a specified time frame. Now, ISDGP and force majeure. COVID-19 pandemic sparkled extensive discussion on force majeure within the ICC task force on guarantees, which led to additional guarantees in ISDGP notes 188 and 195. According to this guidance, force majeure applies under URDG 758 Article 26 only if it disturbs the guarantor's guarantee-related business operations, making presentation, examination, or payment impossible. The mere closure of a bank's physical premises does not necessarily constitute force majeure if remote operations continue. Moreover, ISDGP clarifies that events preventing a guarantor from making payment, such as economic sanctions or something, do not necessarily qualify as force majeure unless they interrupt the guarantor's business entirely. If a force majeure event extends beyond the 30-day extension period under Article 26, the guarantee expires and the guarantor is released from its obligation. Another critical point is that issues with courier service or the unavailability to physically deliver the document do not fall within the definition of force majeure under URDG 758. However, before a guarantee expires, it may be amended to permit electronic presentations, which making URDG 758 Article 14C applicable. Let's consider an example. Suppose you are the beneficiary of a standby letter of credit incorporating ISP98. On the last day of presentation, a severe storm forces your office to close. The bank where you must present your demand remains open. Does ISP98 provide an automatic extension? Then the answer is no. ISP98 Rule 3.14 extends the deadline only if the bank itself is closed, not the beneficiary's office is affected by the force majeure. To summarize, indemnity for foreign laws and usages is crucial for protecting guarantors from unexpected legal obligations in foreign jurisdictions. The instructing party ultimately bears a responsibility for indemnification. Meanwhile, force majeure provisions vary under UCP 600, URDG 758, ISP98 and ISDGP, with different rules on extension and protection. Understanding these distinctions is essential for all parties involved in international guarantee and counter guarantee. If you found this video helpful, please like, share and subscribe for more depth legal and financial tutorials. Drop any questions or topic you would like to cover in the comments below. Thank you for watching and see you in the next video.